I want to take my kid out of state or overseas, but my ex doesn't. What can I do about it? I'm Bobby Dale Barina, and I've been practicing family law for 30 years. And in that time, I've seen a number of instances where one parent wants to take the children either on a permanent basis or a temporary basis to another location. When you're looking at a temporary relocation or a trip, if you're going to go out of state or overseas, and in our situation, out of the country, you have to look at your custody agreement to see if it gives you that ability to do so. Now, going to different places in the country is a pretty easy step on a temporary basis. But going overseas on a temporary basis, you're going to need a passport. Now, to get that passport, it has to be addressed either in the custody arrangement, or you're going to have both signatures with the Secretary of State's office to get the passport for the child. Now, if one parent is a sole managed conservator, which is rare, then that won't be a problem. But a lot of times what we need to do as lawyers is anticipate these problems and make sure that we've addressed the passport language in the divorce decree, allowing one parent to have it to share it with the other parent. Now, I have clients come in often to say, listen, they want to take my child, or a client come in and say, I want to take my child overseas. What do I need to do about it? Well, there are very simple answers. If you have the authority, if you have the passport, you just need to have an itinerary that's something that can be easily read, that shows the destination of the child, to make sure it's not in some current international hotspot. The child will be safe when the child will come and the child will return. If you're looking at more of a permanent relocation, that's a little bit more problematic. You have to examine your custody arrangement to see if you're subjected to a geographical restriction. Geographical restriction is something more and more courts are imposing on individuals. And that simply means that you're allowed to live with that child in a certain radius. It can either be from a school district or from a other fixed location like a capital, either a county capital, a state capital, something of that nature, and you're allowed to live in it. If you wish to move, then you have to ask the court to lift that custody arrangement and that geographical limitation to allow you to do so. And in that becomes a custody fight all over again. You're having to show that that's in the child's best interest and that you were unable to accomplish certain goals for that child in your present location. For instance, if you don't have access to sufficient resources because your job market has diminished in the local location and the ex-spouse won't help you make up that difference, then you can ask the court to move, or ask the court to move because the child will have many more opportunities. You would also build in different visitation schedules to allow the other spouse to still have meaningful time with this child and still celebrate milestones in this child's development. Now, moving, lifting the geographic restrictions, travel, can always present a number of different problems. If you'd like to sit down and talk about it, please drop me a line or give me a call. I'd be glad to talk to you. Thank you.